before you and Ms. Hilton were involved with this particular matter. It looks like that even like on May the 23rd of 2022, Ms. Weaver was kind enough to look in our other record, well, the record from that date, I should say. And the questioning comes up about this discovery, and it's meted out at that point in time by Mr. Farley, Mr. Menendez, who represented Mr. Farley. The colloquy goes as follows. The court, unless you have anything else, you may be excused. Mr. Farley, you may be excused as well. Mr. Menendez, what's the best way to get to discovery is a question I have for the state, so I can drop off a USB or whatever they want to do that. The court, Mr. Geary, do you want to answer that? Mr. Geary, Judge, I'll address that at a later time. We're trying to put these cases on one. Right now, I'm anticipating at least a 5 terabyte drive to put all the discovery on. I'm not at the point to confirm. It's just that it's just yet, but we will soon, Judge. Mr. Menendez, yes, Your Honor, thank you. The court, unless you have any other business, you may be excused. Then from the record of June the 2nd of 2023, Mr. Steele, Your Honor, along with the Honorable Avis Hornsby and the Honorable Keith Adams, we'll be ready for our trial. We understand the enormity. We only have 2 cases for this type of discovery, and I'm being told it's 5 terabytes would fill up the entire hallway of the 8th floor of the Fulton County Courthouse or more. We can't get through discovery, so what we did in other cases, we had a search engine company we already spoke with. I believe I asked Mr. Geary. He's been telling me he'll get it to me, no problem. He's an honorable person always, and we're going to get through discovery. It's like searching Lexus. We're not going to be able to read everything. Nobody's going to able to read all that, but we'll do our search terms, and we are with the court on the 9th day of January 2023. If that gets bumped, because I understand there are a lot of people here, the court may say I want to sever. Some people ask for a continuance that's granted. That's why I filed a demand for speedy trial. I understand, and we'll file it once it's good with Judge Brasher's order, but I wanted to be upfront with everybody and give everybody notice that's our intent. So, and then Mr. Steele has a couple of letters, which I'll include as part of the record in this case, and they're from dated June the 8th, which he's delivering, he says earlier, is his proffer. Dear Mr. Geary, along this letter we are tendering 2 8 terabyte drives, which based on your representation to me should be sufficient size for discovery to be loaded on same in the above aforementioned case. Please advise how long it will take to load the data on those drives. Please also notify me as soon as the copying of the discovery has been completed so we may retrieve the files. And then on the 16th of June, Mr. Steele again follows another letter with Mr. Geary, and he says, as known on Wednesday, June 8th, 22, pursuant to your direction, my coworker, law clerk Law, appeared at your office with an 8 terabyte drive to obtain all discovery in Mr. Williams' case. You directed me to do the same. However, law clerk Law was told by one of your coworkers that you would not accept this hard drive because you would place all discovery on Dropbox. Please note that I'm being told that a Dropbox platform would not be searchable and thus would not be a proper way to handle this massive discovery. I need discovery in the way that you originally told me it would be provided, which would be searchable on a hard drive, and the same would have each piece of evidence that belongs, according to the prosecution, in each count of the indictment and each overt act on the RICO charge. That was very organized, and I would appreciate you allowing me to have discovery in that manner. And pleasantries are considered, but I'll mark that as court 1. So it seems like we've started this discovery travel starting in the summer, in particular May when the original case was indicted, and then June when your other parties were managing this case, and then we had some discussion about the discovery commencing at that point in time. That's why the thus the terabyte drives at that point in time. So I guess my concern, just since I've shepherded this case from its inception of indictment, is that discoveries kind of come in. First, it was promised up front. It was changed. And the parameters were changed. And then, we've had these basically disclosures over the course of 12 tranches of discovery materials. So, I mean, in order for the defense to get ready for this trial, there's a lot of legwork that needs to be done. And, I think part of their challenge and their frustration and the court's frustration is I need to make sure that everybody gets a fair trial, and that it would appear that looking at and the reading of 1716.3, which is copy of the indictment or accusation, list of witnesses needs to be furnished, within the 10-day period. Then 17-16-8, list of witnesses and the requirements therein, to include home address, or better yet, hold on. The names, current locations, dates of birth, and telephone numbers of the parties' witnesses, unless for good cause the judge allows exceptions to requirement. So, and then so A, B, and C of 17, 16, 8 basically tells what you're supposed to, disclose. And then 17, 16, 6 gives the court discretion for failure to comply with discovery requirements. So, the defense has basically said, they're put at odds because of the manner that this discovery came out, the way in which it's kind of been put out, and the like. So I guess my first question is, why didn't you just give them the 5 terabyte dump at that point in time? Because part of the concern that they're having is, well, we could have been spending this 10 months kind of just chasing down whatever else we did. I'll deal with the witness list a little later, but... So, yes, Your Honor. Can you answer for me that to begin with?
As it relates to why the team chose to use a Dropbox medium versus the 5 terabyte medium, I can only assume that because of the length of time, perhaps, that it would have taken to upload it to Dropbox, that they thought that, or versus uploading it to a hard medium.
But they changed the method.
They could have been concerned about the dissemination, as the court is aware that once we provided, this current team provided the defense with a hard medium. The very first time that we did, there was a video that was leaked. There were threats that were made upon a witness's life. I don't know how that happened, but that happened the moment that we provided a hard medium of discovery. But, Your Honor, that effort at providing discovery in no way rises to the level of bad faith asserted by Mr. Steele and Mr. Williams. Here, the state, I have heard Mr. Steele assert many times that Mr. Geary is ready to testify, in making certain that I have the information available for the court. I spoke with Mr. Geary, and he did not make the representations that Mr. Steele proffers to the court that he made. And he said that he would be available to come and speak to the court if the court so desired to hear from him.
I'm not going to cast aspersions on Mr. Geary's office of the court, but I do have some transcript references from May the 23rd from Mr. Menez and Mr. Farley.
Right.
And from June the 2nd from Mr. Steele, asking or following up on this issue with the discovery. And I also have some letter from Mr. Steele on the 8th and the 16th of June. So, and I recall this conversation that Mr. Geary had, saying that, hey, okay, and this further substantiates that there was, or the state was in possession of a large tranche of materials, because we wouldn't have had the conversation
Correct.
at that point in time in June, come over and give a 5 terabyte drive or 2 4 terabyte drives, and let's go ahead and do that. So why was that not done at that point in time is my question to you.
I can speak to the length of time that it takes us to transfer data via the fastest mediums that we have. And given the fact that it would have taken days, weeks even, for us to upload 5 terabytes of data onto a medium that we had previously.
But we had the opportunity to do that in May and June of last year. And if that were, I remember you told me that later.
That was with the faster drives.
That was with a later, but still, you could have done that over the course of a month in June or July of last year.
So is the question to the state why it is that we chose to use Dropbox versus...
No. You can forget the Dropbox issue, because the Dropbox, I already know that was already maintained, that was not a secure way to maintain the files. And in fact, you told me we couldn't do it that way. But I want you to go back to the original question of why. If you don't know, then just say you don't know. But why didn't you put the discovery on a drive? Because it'd be one thing if we said, hey, Your Honor, we have gotten with Mr. Steele and Mr. Harvey, and we've given them their terabyte drives. Mr. Botts, on the other hand, has not come by yet. He didn't come by till September, October. That's not the... And I'm sorry I'm picking on you, Mr. Botts. And it was your birthday yesterday, but you'll get over it, okay?
Happy birthday.
But anyways, but that was not what happened in this particular case. That, from the state, John Geary, Ms. Rosenwasser, Mr. Smith's representation at that point in time, that in particular Mr. Geary, they were going to go ahead and transfer this onto a disk or onto a drive, and why that never occurred. That's the first question I want you to answer for me.
I believe that it was logistics, but I will confirm with Mr. Smith since he is still with the team, and I would, if the court permits me to come back to that in about 3 minutes at most, I can probably do it that way.
So that's my first inquiry. Second inquiry is, why did it take so long to get the discovery to the defense if you all claim you're ready to go?
Your Honor, that was the representation that was made by Mr. Steele, the 97% done. I don't know.
I want to talk about that, okay? I don't think that's relevant. I mean, what I want to find out is, why didn't you all give, or what steps did you take to preside, to make sure that most of your discovery was in fact tendered?
Your Honor, what we found is that we did take great steps to make sure that it was tendered, and we learned that as the...
Send money to bank accounts around the world with Western Union faster than you can skip this ad. There's not much more to it. Yep.
And we ended up serving discovery that we did not even realize had been previously served. And by serving discovery, I mean hundreds of gigabytes. So the data that they received when they began complaining, and for instance, Discovery 12 was the new team trying to ensure that the defense had all of the acts, all of the information. As we went back and went through these gigabytes of data, we wanted to ensure that the defense had everything that we might possibly use. So we ended up serving probably about 2 terabytes of duplicate discovery. We have an audit for 13. We did an audit of 12. I personally was one of the people who put together 12. I literally began amassing files, digital files. The previous team used physical files, and they were copying information and disks from physical files. I had access to digital files that I was not aware or certain that the previous team had access to. So when I started looking at this case, I began pulling data from digital files. I began pulling data that had information that was not relevant to a particular act or to a particular case, and it had information such as perhaps hospital records, social security numbers, things of that nature that had to be redacted before it was served. So that was my own personal effort, along with other members of our team, pulling data digitally from different sources, not even realizing, having come to the team more recently than other members, that we had already provided much of that discovery in the first service of discovery back in July of 2022. So I can say with certainty to the court that the court has seen an exercise of the very best efforts on the part of this team to make certain that the defense is provided with any and everything that we do intend to use. The fact that it was provided over time in different discovery links, I would not call that drips or drabs or tranches, Your Honor. I would say that we have given to them discovery that has been delineated the way that it was represented it would be delineated, by act, by count, in the way that they have requested, the way that it was done. That's literally how the first 9, 10, 11 discoveries, even through 12 and 13, were given to them.
Okay, then why wasn't it ready in July or August?
Why wasn't
discovery? I mean, if you had access to all the stuff and access to formulating it, why didn't you just assemble it all together earlier, like in the early fall, when you and Ms. Hilton and Ms. Uhelski and others came in at that point in time?
Your Honor, as we get ready for the case and as we get ready for trial, I'm certain the court is aware that, you know, different people think different things are relevant and pertinent and would seek to perhaps find value in places other prosecutors didn't. But what we did do was we began reading the file as we were assigned to the case. We began evaluating the file. There is a count 1 on this indictment that consists of 191 acts. And overt acts as to count 1 include, having been here as long as I have, I was aware of cases that I was not certain that the previous team was aware of, and I researched and reviewed files and pulled files and requested data, information that I wanted to make certain was included as a part of discovery that, again, I did not even realize had been previously served via duplication of a physical file. So these were ongoing efforts because we do have an ongoing duty to provide discovery. There is no, it doesn't stop. It does not stop. And as we receive, as we review information that is pertinent to the case, whether it's good or bad, inculpatory or exculpatory, we turn it over. That's what we've been doing. And that's what we will continue to do. And what Mr. Steele has failed to show, or anybody has failed to show, is an act of bad faith on the part of this prosecution team. There is an utter absence of bad faith on our part, Your Honor. And I would point to the State versus Bryant, which is 307 Georgia 850. At 854, just before the Georgia Supreme Court vacated and remanded a case to the trial court, the court noted that the trial court said it found the result of bad faith exercised in failing to provide discovery. On the other hand, the trial court also stated in a footnote that it did not find any ill will nor deliberate action perpetrated by any particular state representative or the state per se, but persistent failure to comply with an ordered process without justifiable explanation. The Supreme Court said these two findings appear contradictory. The latter statement appears to reflect a finding of mere negligence on the part of the state, and the court said that if the persistent failure to comply with an ordered process without justifiable explanation is deliberate, that failure to comply may constitute bad faith. But if the failure to comply is simply due to things resulting from staff turnover, that failure in some circumstances is not bad faith. And that bad faith that is required to impose a sanction of exclusion. Here, Your Honor, that is what we have had. We have had a staff turnover of sorts and a persistent and continued effort on the part of the prosecution team to provide the defendant with the discovery available in this case. I know that prior to our coming to the team that there was an order issued. We were concerned with respect to information on our witnesses and the safety of those names and the security of those persons. The court had entered an order prior to our coming on, but we wanted to make certain that we provided, as we gained access to that information, all available discovery. And I have not one instance heard any assertion by any party, any person that points to any act that even slightly hints at deliberate ill will or an intention to keep anything from the defendant in order to put them in some kind of a bad position.
Okay, I'm the defense, okay, in this case, and I've been getting discovery all along. It's after September the 8th of 2023. The case commenced in May of 2022. On October 5th, I get more discovery, and some of that discovery involves the things that Mr. Steele Mr. Steele kind of complains about, and I have 308 new witnesses. So how am I supposed to get ready for trial knowing that, not knowing whether or not some of these witnesses are duplicative of other witnesses that have been previously provided in the other 12 discovery disclosures, and these particular new, I need to kind of get granularity on the phone dumps and the social media pages, how many there are, but and Instagram pages or Instagram records from 2014 to 2021 of Mr. Williams.
I can show the court that. I can show the court what that is, that Mr.
In terms of what can you show me?
The Instagram records and the social media records. I can pull it up for the court and show the court what is complained of. I just need the Zoom link. I'm going to pull it up. And I've also received word from Mr. Smith that Mr. Geary's reason for sending and using Dropbox was a method to keep track of when discovery was received and opened by the defense so that we could keep a record of when it was.
That doesn't help me.
Okay.
That doesn't help me. Because regardless of whether or not, even though that may be true, and I'm not saying it's not, it still doesn't explain why then you just didn't put it on the terabyte drives and give it to them. I mean, we're always going to have some issues with disclosure, despite the fact that the court signed an order to the contrary. But that doesn't excuse the fact, as you mentioned earlier, that discovery should have been tendered already. Because it sounds like from my conversations or the court's collective conversation with Mr. Geary and Mr. Smith was that a large chunk of that discovery is ready to go. And they need to provide those terabytes so they could get it. All right, so I see your file, enumeration, social media.
That is one of the files.
Is it a YouTube video?
Yes.
Is that it? Does it have any other?
Nope, Your Honor. We're going back. Twitter. I'm clicking on Jeffery Williams. These are the millions of files.
Those are the tweets. It's so there's probably, it looks like.
I can open them up. I can start with the largest one.
I'm just counting how many there are. 16 tweets thereabouts?
PDFs that have individual tweets in
All right,
them.
open up one.
Okay.
Open up number one.
Here's one. This is the largest one that we have.
Okay.
And
That's Slat from Young Thug. Okay.
yes.
All right.
And these are, you can see that a lot of it is blank pages, but,
You need to open it. I haven't seen it yet.
okay. And the other ones are very similar, Your Honor.
Can I see it?
Yeah.
You said you were going to open it, so let me see. Let me see that file.
Oh, it's not showing. Okay, I'm sorry.
No, it's not. You got to. I think you got to close it and.
You do, yes. Okay, and you can. This is the largest Twitter file that we have. Many of the pages in that particular one are blank. I'm going to stop that screen share, and I'm going to open up another Twitter file. This one contains 2011 and 2016 tweets. I will share that with the court. And the court can see, I'm just going to scroll down. It won't take very long at all. The end of the scroll is right about here. And the other PDFs are similar in nature to the two files that I just opened up for the court. I can open up all of them, or I can provide the court a medium and let the court open them up at a different time.
It seems like it's all right, I now see what you're talking about. Okay, so.
And I can go back. Those are the PDF tweets. These are individual ones. There's a countable number. I'll share this screen with the court.
And what are these?
These are individual tweets. I can pull up one. These are, rather than being pages that have the multiple tweets in them, these are individual tweets, such as the one on the screen now.
Okay.
So those that I have shown to the court that are here, they contain one tweet per PDF.
All right, so how many PDF files
PNG.
do you have at this point in time?
How many are there?
Okay, it looks
I
like we
can-
got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11,
44 selected
44
items.
items. Okay.
Yes.
All right.
And
Is that from the period of time that you are planning to introduce?
yes,
Okay. What is that representative of? What period of time?
That goes from 2011 through 2021.
Okay. All right.
Also, Your Honor, as it relates to Jeffrey Williams, as far as Instagram is concerned, we have this photograph. That's the Instagram file. As it relates to other items that are in Discovery 13, I'm unaware of where millions of documents are as they relate to social media for Mr. Williams.
May I help, Your Honor?
Yeah, are there any other ones on this file that you're talking about, Mr. Steele?
If Ms. Love would please go to the file named Other YSL Information. There's a subfolder, Search Warrants and Returns. There's a subfolder, Jeffrey Williams. And Ms. Love can share the screen.
I sure will.
Thank you.
On the screen is Jeffrey Williams' Instagram return.
And there's some 2,842 positive responses?
Pages. They have information such as what the court is looking at now. I can scroll down just to get to
This is source information you're talking about?
Yes.
Okay, all right, and there's some, so last thing I saw was 532.
yes, I can go back there.
Can you go back to that?
Yes. That's at page 532. I'll just
So how many
scroll
pages
down.
of identification data do you have? Like from when does after the identification or location data, when do you have pictures or any other things that?
Judge, there are other files in the folder. What we can do is go through those folders and look at those folders and those files.
Your Honor, all these have pictures, and if you look at the file in the same area of returns, you will see 10.7 gigabytes. That is, I'm told by Surrey, it's also Google. That's 200,000 PDF pages is 1 gigabyte, so that's more than 2 million PDF pages. It's in the same area under returns.
And so if Mr. Steele would just give me the file name that he's referring to, I can pull it up and let the court see it. I can share it.
Return.
The return has several file names. All I need is a number.
Jeffrey Williams, Commissioner.
All I need is a number. Just give me the number. Which one?
Oh, all of these. Well, look at all of these are the
You do realize that
Instagram.
this is a compressed version of that. So which one? There's an affidavit. Which one?
Try that one.
Sure. This one, the compressed version?
showing the screen?
Yeah, I was waiting on it to come up. Here is the screen. The registered email address is slatseason@gmail.com. Thugger1. I have pulled up the here we go.
Okay, let's see, starting, okay, keep.
Got it, every blue line is another messaging picture, every single one.
After, starting at 5401, or?
No, it starts earlier.
The
Now,
court can-
I mean, some of the file is identification data. So when do the actual pictures start from this particular file of, it's 26,118. I'm looking at the number of pages. So when does the picture start in this file? I mean, I know you got a lot of identification data, but at,
It just takes the pictures a minute to load, but every blue line is a spark, it's a new picture at all. All of the things you see right there is just like comments on the picture. But if you just could load, everywhere on one of those blue lines is a new photo. And then the comments are what you're looking at now.
So, Your Honor, I will go back up to the very beginning and just take it page by page. Slowly.
like those pages are blank.
If they say 26,000, that's how many photos it is.
And, Your Honor, I'm just scrolling slowly so that if there is a photo on the page, it has time to load.
Files 127,000 photographs.
You open,
Whichever folder council would like me to open and share, I can do that. If they give me the number, I will open that one up and share it with the court.
can you go to John's list of files, please,
Yes.
and show that?
Oh, wait, that's not it.
Can you go to folder 12205, I'm sorry, file, 1220455, 485, 157, 430. It says it's 1,600,000.
I just clicked it and I'll stop sharing this screen for return so that I can share the particular file council for Mr. Williams requested.
That's 1.6 million kilobytes now.
Are you opening it?
Yes, Your Honor.
Thank you.
It's loading, but it's not showing.
But it opens, I have 127,600. 127,603 pages on this file.
And that is about 1.6 gigabytes of data that counsel or representative for Mr. Williams is referring to.
Okay, so how many pictures?
And a movie is like,
How many pictures does that represent?
how many
I want
individuals?
to see the folder. so.
Okay. Put it on a terabyte drive. This is server. Okay. I'm gonna use it. Would you ask them if they'll bring the terabyte drive that has the discovery on it over so that we can just load that up rather than trying to go from the server? Your Honor, I'm pulling this up from our server, and our server is slow, so I'm asking that counsel bring over the terabyte drive that has the discovery on it so that I can load that quickly. If the court will permit me to pull that up when he gets back with that, or when he's able to get a member of our team over here so that we can pull that up for the court.
All right.
Additionally, Your Honor, these are returns for the social media pages of Mr. Williams. They are, obviously they are not items unknown to Mr. Williams. They are items that the state has secured in order to utilize as evidence in this case, but they are more known to Mr. Williams than anyone else.
When were the records available, or when were the records procured? Were they procured back in January of 2023, or when did you all get the records from? From the social media providers.
In order to get it. December 30th, 2020. Your Honor, there is an order to produce Jeffery Williams' Instagram from 2014 to 2021, signed by a judge on December 30th, 2021.
And when was it actually tendered by Instagram?
So it was, search warrant was December 20th.
When did Instagram send?
I'm looking for that.
When did they finally, answer that request or?
I'm looking for that, Your Honor. Search warrant. Returns inventory.
Bless you.
Asked someone to get the terabyte drive off of my desk. And let me find out. I'm finding out about the Instagram search records. And since they were procured by Investigator Miller, I'm looking to see what date that they were secured. There's a modified date on here, so that looks to be perhaps the date that it came back, of February 7th, 2022. But I can't say that that's the date that we got them back. And I can say as well, Your Honor, that any information that we have provided has been the result of ongoing efforts to make certain that we've served everything that we have and intend to use. So if the court would give me about 10 minutes to go check with my colleagues and to get this particular file, or I can wait until they're able to bring that over with that information and continue on. But to answer the court's questions, I need information from my team.
Yeah, I think you probably should figure out when, my concern is that if you had the information in the spring of 2022, why didn't you just tender it at that point in time?
Your Honor, I can...
If you tendered the whole thing and then cherry picked out what you wanted to use, then the defense would have been put on notice that, hey, you had this very large file with a bunch of Instagram photos and everything else, but at least it kind of puts everybody on notice that, hey, here's something that you're going to have to kind of look through. Some of it may be exculpatory, some of it may be inculpatory, but getting it now, or getting it, in October, that's a little bit much.
Your Honor, I understand.
You see my
that
concern?
position.
You see my concern that it's from my perspective as a court, there's a great possibility you've had this material for at least the better part of 6 months.
I don't
That's
disagree.
my concern.
I don't disagree with what the court is saying.
And that's my concern about, Mr. Steele saying, hey, given the voluminous nature of this file, that's a lot. That's a lot for anybody to have to go through.
Your Honor, I don't disagree with the assessment that it is a lot that anyone has to go through. Certainly, it's a lot that the state has to go through, and it wasn't a matter of holding back.
But you had it.
I'm not disputing anything. What I'm saying to the court is that we have files in multiple different places digitally. I personally have attempted, Ms. Hilton, Mr. Uhelski, every person on this team has attempted to make certain that we have gathered through the universe of our data the information that we intend to use in this case. If there were instances where information was not served, we have gone back and asked, was this served? In some instances, we thought stuff was served. It wasn't. We served it. And in some instances, we did not realize that it had been served, and we served duplicates. That's the ongoing effort.
Okay. This file doesn't look like it's a dupe. That's the
So,
problem.
Your Honor, I didn't hear the court.
This file doesn't look like it's a duplicate.
It doesn't appear to be a duplicate, Your Honor, and I'm not disputing that. What I'm saying is that at no time did the state or anyone, any member of this team attempt to not provide to the defense information that we intended to use in this case. We have been getting information from different sources. We have been communicating with different investigators that have been on the team who are in different areas of the office or in other offices altogether to make certain that anyone who had information pertinent to this case, and there were multiple investigators working on this case, some of them are no longer with our office. We have reached out to them. We have tried to make certain that everything that we have on this case is provided to the defense. And Your Honor, the reason that I have a problem with the idea that we are acting in bad faith or that we are trying to withhold information or that the court should exclude the defendant's social media accounts is that, one, if more time is needed to go through the social media accounts, more time could be allotted by the court. What we are asking is that the court does not employ the extreme remedy of exclusion of relevant, pertinent information on the basis of it's an inconvenience to go through. I don't dispute, I'm not arguing.
That's more than an inconvenience, Ms. Lowe. That's a Herculean task to go through if it's as many photos and files as I think it is, but I'll pause on that until you can load that thing up and show it to me. But let's turn and talk a little bit about this witness list. Okay?
Yes, Your Honor.
What is the current witness list for the state? How many witnesses do you have?
Your Honor, we have provided that to the court and to the defense. And we have not only provided that, we have included on that witness list a index that points to which case that they will be used for. We have provided phone numbers, addresses, email addresses, alternate phone numbers. We have provided everything that we can get our hands on as it relates to each witness that we've provided the name for on our list.
Okay, so how many, I'll go back to the original question. So how many witnesses do you have on your witness list at this point in time?
Would you pull up our witness list, please?
Can you give me a number?
I will, Your Honor. I'll pull that up.
And while you're thinking about that, I also want to know.
I'm gonna
well,
reference-
first get me that number, and then I'll ask my next question.
Yes, Your Honor. Do you have the witness list? 258 lay witnesses, Your Honor.
It says 258 lay witnesses.
Yes. And 479 professional witnesses.
All right.
Will the court permit me to take my seat at the table so that I can pull up the files from the drive that I'm holding in my hand?
Yes, ma'am.
Thank you. Can you get this? Dan, can you grab this thing?
Okay. How many, this is the current witness list as of now. 258 in terms of lay witnesses, 479 in terms of professional witnesses. Is that correct?
Yes, Your Honor.
How many witnesses did you have before September the 8th of 2023?
On an itemized list, Your Honor?
Yeah, because Mr. Steele, the last service of your witness list as of September, I should say, as of the October 13th, that's when it was represented that there was nearly 700 witnesses, a little over 700 witnesses. So between October, I should say between September the 8th and October the 13th, what did the witness list expand by? Now, Mr. Steele told me the original witness list had 36 on it. That was from December the 8th of 2022. Then it went to some 47 as of 3 January 2023. Then it went through to 179 as of 23 March of 2023. So what was it in September the 8th of 2023? How many witnesses did you have at that point? I mean, I can.
I'm fine. Your Honor, the court asked between September 8th and September 26th.
How many witnesses did you have? What did the witness list grow to on September the 8th of 2023? How many witnesses did you have at that point in time?
Okay.
Because it looks like from March of 2023, you had about 179 witnesses at that point in time. Then in September, you had another increase in witnesses, and the last increase was the one that was about 300 in nature. I think if the court's memory is correct or somewhere around there, you had a little over 400 witnesses in September, about 437 or something like that. And then it appears that Mr. Steele and the defendants, when the last witness list came out, I want to say 13 October, that's the one that had the a little over 700 witnesses, and to your count, 737. Because we had a discussion at that point in time about the witness list and whether or not Mr. Steele apparently asked me at that point in time, well, then at least run the GCICs on lay witnesses. We had that conversation about, the statutory power and the power that the state would have. So I remember that from that particular time period. So my question at this point in time is the 737 inclusive or exclusive of duplications? Meaning that are those the universe of people that could be subject to being called in this case? The 737?
Yes, those are subject to being called in this case. When the court asks whether they are inclusive or exclusive of duplications, is the court?
Yeah, are any of those duplications, is that the known true universe of witnesses that may be called to testify in this case?
I believe it is, Your Honor. I believe it is, and what I want to do is pull up the witness list that we sent to the defense on September the 8th so that I can make sure that I'm answering accurately for the court.
Yes, ma'am.
Hey Georgia, looking for quality, affordable health insurance? At georgiaaccess.gov, there are many great ways to find a plan that meets your needs and budget. Open enrollment begins November 1st. Georgia Access. Your health, your way.
So on September 8th, it looks like we had 632 witnesses. If I'm looking at, yes, it looks like we had 632. And then the court asks, what number did we have on a different date?
On October the 13th. All right, let me ask you another question, Ms. Hilton. I should say Ms. Lowe. How many witnesses of that universe of potential witnesses that you have identified do you realistically think you're going to call? Give me the number of fact witnesses and give me the number of expert witnesses that you have. Your case-in-chief witnesses.
Your Honor, the case...
Fact and expert.
The case in chief, Your Honor, consists of all of the ones that we've served, and the reason is that the count one consists of 191 acts, and the reason that it
Well, you've
grew
got also
to,
some defendants that are no longer in this case. So
right.
are you still going to present those, or are you going to pare down your indictment, or what are your plans on that?
Our plans have been to pare down the indictment, Your Honor, and we obviously move things around as different things happen. But given that there are overt acts that were committed by people who may not be at the table that go to show not just the existence of the enterprise, but the current defendant's participation in it, and as well as the pattern of racketeering activity that we allege that they conspired to commit. It's not just, it would be different if it were just one murder or just one aggravated assault or just one burglary on the indictment, Your Honor, but there are a list of acts that we seek to show, to introduce as evidence, to show the pattern of racketeering activity that they conspired to commit. So, yes, we are still, even now, endeavoring to take out some of these people, and because we want to present the most effective case for the state. And there are some that, there are some of these acts that we feel may not do more than, other acts. And we don't want to lose the jury's attention or anything like that. So we are even now paring down the list. But we have sought, so that there is no confusion and there is no assertion that we did not put someone on notice, we have sought to extract from the discovery that we have provided all of the names of the people that we look to call in this case. We have made great efforts to make sure that we do that, because even though they are listed in discovery, we have attempted to comply with the court's directive that we provide an actual list that has as much information about each witness, including what count they will be called for, on the list. So,
it seems like that if my math is correct, that as of the 8th of September, you had 632 witnesses or thereabouts, and as of the current, you have 737. So since September, we've had at least 105 witnesses. Am I off? Do I disagree?
Your Honor, I would say that the list itself may now include that number of people, but again, these are people that are identified in the information that we've provided, and we've sought to extract from that information and make certain that we've listed all of the people that we anticipate using at trial. But, these aren't people that are new to the case or newly made known to the defense. And we certainly aren't and haven't attempted to hide any witnesses or anything like that. And I think the last witness list that we served was I think the court said it's September 26th, not October 13th. That was the date that Mr. Steele filed the witness list. We did not file one on October the 13th. We last filed the witness list 2 months ago. And while we're not asking that anybody make a decision about whether or not to file a speedy demand or forego having an opportunity to properly interview witnesses, Your Honor, we put forth that given that we are making efforts to present and give to the defendants, at least a week out, what witnesses that we intend to call, we would propose that rather than even considering excluding them, that the court simply require that before the state puts particular witnesses on, that the defense be given, that opportunity to interview the witnesses.
Okay. I have it's almost 12:30 at this point in time, and I understand that lunch is available for some, and I am going to recess to allow that to occur. And I have other unrelated business that I need to take up during this particular lunchtime period. So the court, just make sure. Let's say we come back for, let's shoot for 2:30. In the pendency, please find be able to queue up the video file. I want to see that, not video, no, but the file that, there's two files that are relatively large.
Okay.
I just want to be able to see those. And then we can take things from there, okay?
Your Honor, may I ask just before we recess an administrative question?
No, I need to take it. So
Okay,
what's your administrative question?
I just wanted to, in regard to the constitutional, I do have some exhibits. I know Your Honor said that they were due by noon. We'll take it after lunch if that's fine.
You can hand them out to the other parties should you choose to do so. Okay? Yeah, go ahead and do that. All right, we're going to be in recess until 2:30.
Thank you, Judge.
Thank you, sir.
We'll be back, y'all, at 2:30. We're in recess, or they're in recess. We'll be back, y'all. Hold on. 2:30. They're in recess until 2:30. So that's when we'll be back. 2:30. All right. Peace. Y'all go ahead and get some lunch.